On December 27, 2022, 24-year-old Brian Camp was home asleep with his girlfriend, Brooke Janik, and their 2 young children. While they slept, 27-year-old Jonathan Letendre broke into the home. He is Brooke's ex-boyfriend. Jonathan attacked Brian. Brooke woke up and called 911. The men continued to fight. Then a gunshot goes off. Jonathan, the intruder, is struck. Meanwhile, the 911 call continues and records everything that happens, including a second gunshot 8.5 minutes later. The second shot ends the life of Jonathan. After law enforcement responds and investigates the fatal shooting, Brian Camp is charged with manslaughter. Prosecutors claim the first gunshot was justifiable and self-defense, but the second gunshot, more than 8 minutes later, was homicide. Tonight, we take a close look at the interrogation of Brian Camp as he describes what happened and why he fired the second shot. But first, Whitesburg, Kentucky is a small rural community of under 2,000 residents. It's the kind of place where everyone knows each other, and in many circumstances, they have both personal and professional connections. It's a place where the word homicide is rarely spoken. In fact, it was one of the few places where you could walk into the courthouse without going through a metal detector. But that feeling of comfort and safety was shaken on the afternoon of September 19th. That's when prosecutors say the elected Sheriff Mickey Stines walked into the chambers of District Judge Kevin Mullins for a private meeting. What happened next, no one in this small town expected. The sheriff called his daughter from the judge's phone, then stood up and fired his gun, taking the life of Judge Mullins. The sheriff then walked into the courtroom, laid down his gun, and surrendered himself. Tonight, huge developments in the case as the grand jury hears the evidence, and we get the latest from our Kentucky insider as everyone still waits for the answer to the one big question: why? I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. The first time I heard about this story out of Kentucky, right? A judge is shot in his chambers. First question is, well, who kills a judge? Like, who kills a judge? We've had cases where judges have been shot in the past here on Court TV and other cases in the news, and by and large, it's usually someone who at that time is mentally unstable. Oftentimes, it's someone who's litigating a case in front of that judge. Most of the time, it's someone in family court, to be honest with you. Someone who's emotionally breaking down. This is different, though. That's not the scenario here. It was the sheriff, a friend, a colleague from this small community. So the question is, for the sheriff is, will he admit it? Now, he allegedly confessed already, but will he admit it in a courtroom? Those are two different things. Getting into a courtroom and either admitting it in front of the jury or admitting it and pleading guilty in front of the judge, or admitting the shooting and the killing, but explaining why. Is it justifiable? What was it? Why did this happen? And again, that's the underlying issue in this case from the beginning, always has been, because of who the sheriff is and who the victim is. It's the sheriff, it's the judge. It's a small town in Kentucky. You want to know why? And yeah, we've heard all the whispers out there, but none of that counts for anything until we hear something inside of a courtroom. And this small community is still shocked by all of this. You can't imagine how that undermines your sense of safety, your sense of right and wrong and what's going on. And then everyone's, I'm sure, again, talking about it and trying to figure out, well, what happened? It seems most people like both guys, that there wasn't like, oh, yeah, I don't like that. No, both guys seem to be well-liked, respected, popular. This seemingly came out of left field. But there's something we don't know. There absolutely is something that we don't know. What I do know tonight, though, is that there was a grand jury listening to the evidence in the case, and a grand jury that has returned an indictment. And I've got the details right here from the Attorney General Coleman, and the Commonwealth's Attorney Steele announced a murder indictment of the former Letcher County Sheriff. On November 21st, 2024, a Letcher County grand jury indicted Stines on one count of murder, public official. Murder of a public official. According to the indictment, Stines shot and killed Letcher County District Court Judge Kevin Mullins. The arraignment set for Monday, November 25th at noon. The Kentucky State Police investigated the case. Commonwealth's Attorney Steele and Deputy Executive Director of the Attorney General's Special Prosecutions Unit, Ranzi Dallam, presented the case to the grand jury on behalf of the Commonwealth. So the wheels of justice are starting to turn now. Starting to turn. And Monday, back in court for an arraignment. So let's get a little more information, a little more context. We need an insider. We have one. Joining me, the attorney representing the woman who is suing former Sheriff Shawn Stines. Ned Hildersdorf is with us. Ned, great to see you. Thanks so much for joining us. Okay, let's start with the big picture. What does this mean, this indictment?
What it means, he's going to be arraigned Monday, and the real question is, what kind of bond, if any, does he get out of jail? There was a quote from the judge who received the indictment today, that she is going to set a bond, and will, quote, be a significant one, which means a cash bond. The fact that in the release you read, they mentioned that he was a public official, that's potentially an aggravating factor that could mean this is a death penalty case. It is unusual in Kentucky for a death penalty case to even talk about a bond. I assume the judge will set a bond. I assume it'll be high, and I guess the speculation today is, will he be able to raise the money? How high will the bond be? The problem is, you don't want to be a criminal defendant in East Kentucky. Generally, from arraignment to trial date, you're talking 6 months. And you especially don't want to be a criminal defendant, if you can't make bond. Our Kentucky jails are overflowing. Our circuit courts are more than overflowing. And the fact that we may be looking at a trial that go on 4 or 6 weeks will put a real burden. And I guess the next question is, of course, the speculation is, can they even try this case in Letcher County? Is it possible to get a jury there? I've actually, I think, tried 4 murder cases in Letcher County, 2 death penalty cases. It is a small, isolated community. It borders on Virginia. And you're right, Vinnie, everybody knows everybody. And especially in this case, the 2 most recognizable human beings in Letcher County were former Judge Mullins and Sheriff Stines. They're both popularly elected. And they both have, I would say, universal name recognition.
What's your sense of what the temperature is on the ground there? Is there, and it seemed the last time he appeared that his family is supporting him. It looked like they were in court standing by him. If you're a sheriff, you at one point had people who would support you, whether it's professionally or personally in your life or politically, who help you through that whole process. What's the temperature on the ground in terms of the support for the sheriff versus those who have turned against him and feel like this guy needs to pay the price for what he did?
I would say it is bitterly polarized. You know, we live in a different world now where people comment on social media. More people probably get their information from social media than 30, 40 years ago from newspapers or television. Judging by the social media, there's people all over the place. There's some of the worst rumors you've ever heard that I'm not going to repeat. And it may well be that there is, I even hate to say this, a choice of evils defense, a time to kill defense. And you're right. Sheriff Stines is not an unintelligent person. This is clearly a crime of, I would say, passion. Why did he do it? I've heard every rumor in the world. And what happens in the real world is the people who know nothing about it are talking. The people who might have a good idea of why this really happened aren't talking. But I would say the community is very polarized. And to me, while change of venues are very rare in the real world of practicing law here in East Kentucky, I see a change of venue in this case. And I don't even know if they can try it in an adjoining county. We have a situation here, thanks to your show. I mean, the national media is very interested in this case. And then you're talking about a small community, a polarized community. Sheriff Stines was a popular, charismatic person. I'm not a great admirer of him. I've actually sued him twice. But I see a very polarized community. And if it's a potential death penalty case, then you go through the scenario of individual sequestered voir dire. And the real world of trying death penalty cases, if it's a death penalty trial, what would normally be 2 weeks, you're talking a 4-week trial, because it generally might take 2 weeks to pick a jury. So I think trying the case in Letcher is problematic. That's an open question. And the real question is, does he get a bond, and can he post a bond? Cash bonds in Kentucky, like everywhere else, are controversial. There was a movement in Kentucky, which I supported, to try to eliminate or limit cash bonds, and that got nowhere in the legislature. And the judge did indicate today that she's going to set a bond. But ironically, I was in court today with Mr. Steele, the prosecutor in adjoining county, and he asked for high cash bonds for my client, who's not even charged with murder, and the bond was set at $500,000. That's not unusual, by the way. It'd be interesting to see what the bond is set in this case. It is potentially a death penalty case, although from my wild speculation is I don't think they'll seek the death penalty, or if they do, they'll do it simply for leverage.
Right. So going back to what happened here, like there's the video. We've seen the video because there's a camera in there. Now, the sheriff knew that there was a camera in the judge's chambers, right? Because wasn't this all a result of the inappropriate sexual assaults that were taking place after hours in the judge's chambers by one of the deputies?
I don't know that that's true, that Sheriff Stines knew there was a camera there. To put it in context, the lady I represent alleged that she was basically raped or sexually abused in chambers. I have heard afterwards that cameras were put in chambers, but it is very unusual for there to be cameras in chambers. There are cameras in the courtrooms and in the judge's conference room. But frankly, I've never heard of a camera in chambers of a judge. I've read media reports that the cameras were installed there as a direct result of the litigation I'm involved in. But I don't know that Sheriff Stines knew that. You know, but frankly,
isn't he in charge of security? Wouldn't he be in charge of security though? Like, isn't part of his responsibility in that building, in that courthouse, to protect the judges? So if there are cameras placed around the courthouse, I would think the sheriff would know, or is that not part of his responsibilities necessarily?
You know, frankly, looking at the video, I don't know that he really cared that he was being videoed. He clearly wanted the judge to die. I mean, what, 8 shots in what, 27 seconds? And especially that last shot was just hard to watch. I don't know that he cared that he was being videoed.
Right, and that gets me to my point, Ned. If he knows there's a camera there, and he turns himself in, like, he knows, like, by doing this, what's going to happen next. He knows what the evidence will be. So I'm wondering, like, again, it comes back to that question of why, right? Like, what would drive a man of the law to do something like this? In other cases where judges have been the targets, I've seen defendants who are emotionally unhinged at that moment, whether they're going through a mental breakdown. More than once, it's been a family court judge, because you know how those family court cases can get way out of control. So people are so emotionally invested, and if they feel like they're losing and everyone's against them, you know, they can start to have some sort of a mental a breakdown. But I don't know if that's the case with the sheriff or not, but it would seem you'd almost have to be in that state knowing that you go in there and do this, it's over. It's over unless you have some real compelling story to tell to a jury.
That is the question we're all thinking about, Vinnie. I mean, it may well be the judge did something that he felt so outraged about that he went through some sort of psychotic rage. It may be a worse intention that he thought the judge maybe was going to report him for something he didn't want reported. We don't know, but I think whether he knew the cameras were there or not, I don't think he really, pardon my language, gave a damn. I don't think he cared that there was a camera there, and whether he knew there was a camera there or not, I don't think that mattered to him. The real question is the way the case will come down. If you're charged with murder in Kentucky, we have what's called a subjective state of mind jury instruction. The jury will ask, when he did what he did, and there's no question he did what he did, what was his state of mind? And it may be almost sort of a jury nullification that, in his view, the judge is something so outrageous, he was in this uncontrollable psychotic state. There's been some suggestion at the preliminary hearing that maybe this is an extreme emotional disturbance defense. If I'm defending Sheriff Stines, and once again, I'm not an admirer of him, I've sued him, I don't know that an extreme emotional disturbance defense does you much in Kentucky. That's a 10 to 20 and you serve 85%. So let's just say he gets 15 years. It means he's still sitting in jail 13 years. This is a guy who doesn't look particularly healthy. And he's got to hit a grand slam at trial.
Absolutely.
I don't know what his defense is. His defense may be a time to kill, that the judge did something so unconscionable, he needed to do what he did in his own mind. And that may resonate with some jurors.
We shall see.
You know, on the other hand, I wasn't as sure he was actually going to get indicted because he was so popular. But after that video aired, there was no question in my mind he was getting indicted today. The video is beyond shocking. And I'm afraid Letcher County is going to be on national television for a while.
Oh, you will be. Court TV is not going away. Ned Pillersdorf, our Kentucky insider. Always great to speak with you. Thank you so much. All right, folks, when we come back, we're going to bring in our think tank. We're going to take a look at a big case happening on Court TV. Is it self-defense? Is it murder? It's a tough call on this one. Plus, coming up next hour. Tonight on Vinnie Politan Investigates, it's the biggest case on our docket at Court TV, the Idaho student murders. How did investigators link the suspect to the crime scene? Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, tonight, 9/8 Central, only on Court TV.
24-year-old Brian Camp is charged with manslaughter in the death of Jonathan Latender.
He was 27 years old. He was the general manager for Dunkin' Donuts. And it was through his work at Dunkin' Donuts that he met a young woman named Brooke Janik. During a break in Brooke's relationship with Mr. Camp in early 2022, when they had split up, Mr. Latender and Ms. Janik struck up a relationship.
Their relationship was brief. When she went back to camp, Latender did not take it well. And on December 27, 2022, Camp, Brooke, and their two children were sleeping at a home when Latender broke in shortly after midnight. Brooke heard someone coming up the stairs and screamed.
And then before I even could see, because I just woke up, before I could even see, there was some guy standing in the doorway. Before you know it, the kid's on top of me. Mind you, I had no clothes on. I'm trying to wrestle this kid. I don't know, he was trying to dig my eyes out, telling me he was going to kill me.
Investigators say that there was a brutal fight. Brooke called 911, and on the audio of that call, a gunshot is heard. Then about 8.5 minutes later, she reacts to a second gunshot.
Okay, you just heard another gunshot?
Latender was shot in the torso and in the back of the head. Prosecutors say the first shot to the torso was lawful and in self-defense. They claim the second shot was not, but the defense alleges Latender was still able to move and still a threat.
Mr. Latender was able to move, was moving, and that Mr. Camp, after all of this, believed that he needed to shoot again because he needed to stop this thing because it clearly was not stopping.
Camp pleaded not guilty.
Yeah, and I shot him because the entire time he'd been telling me he's gonna kill me.
This is really an unusual case. I've never seen anything quite like it. The victim in the case commits a home invasion in the middle of the night and attacks and threatens to kill the defendant. And it's all about the space between the two shots. And now they've charged him with manslaughter. Brian Camp in court claiming self-defense. I mean, he's sleeping, he's naked. Somebody breaks in, he shoots him. But 8 minutes later, apparently shoots him again. So I want to take a look at the police interview. Brian Camp explaining to investigators what he says happened.
She woke me up, said she heard something, which isn't unusual. I told her, no, there's nothing, you know. I didn't get out of bed or anything. And then I guess she heard it again or just had a feeling. And she got up and like her head didn't even go around the corner. And she screamed and came back in. And then before I like even could see, because I just woke up, before I could even see, there was some guy standing in the doorway.
Okay.
And then...
And this is the doorway of your bedroom?
Yes. I don't even know how it started, but before you know it, the kid's like on top of me. Mind you, I had no clothes on. I'm trying to wrestle this kid.
Completely naked?
Oh, yeah.
Okay.
Oh, yeah. And, I don't know, he was like trying to dig my eyes out and telling me he was going to kill me and all this stuff. And I don't know, he started bleeding up there. Something broke. I heard something smash. And then now all of a sudden he's bleeding like crazy. I had him in a chokehold and he was still trying to dig my eyes out.
Okay. Now when you say you had him in a chokehold, describe how that was. Were you both on the floor? Were you standing?
Both on the floor, and I had him like around the neck.
Okay.
Like that. And like...
And was he on the bottom and you were on the top?
Kind of more like side to side.
Okay.
And then I thought, like, after somebody choked me out like that, I would, you know, you got me, right? And so I ran downstairs, mind you, still naked. I hear this dude coming down the stairs, and...
When you choked, was he unconscious?
No,
Okay.
He wasn't unconscious, no. And because I let go of him before he dug my eyes out. Somehow, he got a hold of my muzzle loader, which was like leaned up in the corner, because I've been hunting every day, right? And
and where was the muzzle loader? Up in the corner where?
like by the bottom of the stairs, there's I don't know what to call it. It's like like a low shelf, but it opens up.
Okay, yeah.
And the muzzle loader was over there. And then we were wrestling for that, and luckily, I opened the thing and dumped the primer out of it.
So I had a primer in it?
Yeah.
Okay. Elements and the round were all in there?
I would assume, yeah. I mean, I was ready to go hunting. I did go hunting with it yesterday.
Okay.
And, I dumped the primer out of it, at least I think. And then he tried to shoot me with that thing. Then I grabbed this old, decrepit shotgun that was like together, but not together.
Mm-hmm.
You know what I mean?
No.
And
I don't. Explain.
so like this chair might look like it's there and
Yeah.
all put together, but you touch it
Okay.
and the arm falls off, this falls off, so like it would not have functioned.
Okay.
But I just grabbed it as like if someone pointed a shotgun at me, I would get out of the house, you know what I mean? And then he tried to grab that from me, so I ripped it back and the barrel came off of it.
Okay.
And then so I had the stock and he had the barrel, And I think that's what he hit me in the head with, was the barrel.
Okay.
And
so if you got hit in the head at some point, you think it was that barrel?
yeah. And then he cornered me in the kitchen, and I don't know how, but I remembered that my handgun was way on top of the counter.
Okay.
And I grabbed it, and I
was way on top of the counter, like on the shelf?
The top cabinet.
Okay.
You know, way on top. Like, you gotta climb on the counter to get up to the cabinet.
Because they're not connected, so.
Right. Yeah, and I shot him. Because the entire time he'd been telling me he's gonna kill me. And that's about it.
So you said you think it was one shot, maybe two shots?
Yeah, like I said, maybe two. I don't know, I have this reoccurring nightmare about something like this happening and my gun not going off. And like,
Wow. Let's bring in the think tank. Joining us tonight, criminal defense attorney Eklund Mercy. Also with us, retired criminal defense attorney Kirk Nurmi and former federal prosecutor Nima Rahmani. Oh my goodness. What I mean, he gets attacked in the middle of the night, Eklund. He's on trial for manslaughter. What's going on here?
This is why it's important to exercise your Fifth Amendment right to silence and request an attorney. The issue is that we see this often, especially when you think you're in the right and you think that, you are in the right, you believe you're in the right, you're justified, and you think that the police officers are on your side. They are law enforcement. That is another entity. You need to protect yourself and request an attorney. I need an attorney. At that point, all questions should be ceased. That doesn't mean that the information wouldn't come out. However, it would have come out in a way that would be more, that would be in his best interest. Right now, he has blood on his face. He has defensive wounds. He is still under the shock of everything. He was naked when he was fighting with the alleged victim. I don't know why they charged him. So I mean, I know why they charged him, but the issue is that it shouldn't have gone this far. I believe that at that point, he should have requested an attorney and stopped questioning. And I don't think it would have been to the point of trial right now.
Kirk Nurmi, I could not imagine being a juror on this case. And it's like a man breaks into my home in the middle of the night and says he's going to kill me, grabs a shotgun, tries to shoot me. Won't leave. I choke him out. He won't leave. I point a gun at him. He won't leave. And now I'm the one on trial for manslaughter. I mean, is a jury going to send a guy like this to prison?
I have a tough time believing that they're going to send Mr. Camp or label him a felon. Likewise, because that would label this person who broke into the home, threatened to kill him, etc., had a knife, handcuffs, things of that nature. They had children present in the home, right? I don't think any jury is going to actually convict a man for this. Now, I understand the charging, but, it makes me wonder what's going on in Massachusetts here, right? Are we just going to charge anybody when we don't have evidence? Because this is the second case that we've seen of that nature. And here we are now with this guy on trial because there was an 8.5-minute delay. But we know that there's, all we need is, I guess, a little bit of forensics to bear out his story, and that's all the jury's going to need to hang. I cannot imagine, maybe I'm completely off, but I could not imagine this guy being convicted.
Nima, this isn't one of those cases where it's like, the shooting takes place, he flees, you got to track him down, and then they say, oh, it was self-defense. Like, from Jump Street, right? This is self-defense. We saw the body cam when police respond. He's there on the front yard. I mean, where are we? Like, this is Massachusetts. I get it. If this was Florida, I don't think we'd be talking about any of this right now. I mean, really? Like, this guy, the victim in this case came on a mission to kill that man. and got killed, and now the victim of the initial home invasion and assault is on trial. That's nuts, it seems.
Vinnie, you know me, I'm as pro-prosecution as it comes, and we've covered a lot of self-defense cases here on Court TV, but this is probably the worst for the prosecution that I have seen. I mean, this is a case that's really marching towards a not guilty. I agree with Eklund. Obviously, you shouldn't give a statement, but as far as statements go, this is a very good statement for the defense, in my opinion. He is talking about how he is genuinely scared for his life, and the victim, Jonathan, is making threats actively. Doesn't get better than that. It's either reasonable self-defense or unreasonable. And this isn't someone that killed 8 minutes later because he wanted revenge like the state says. So I don't even know if I even want to use this statement if I'm the prosecution, because it's so good for the defense. And I agree with Kirk. I don't know why he's on trial. I don't know why he's being prosecuted. Here's someone who really was defending his home. And I think that self-defense, especially deadly force, has been used far too often in this country. But this is a textbook case of self-defense. And I understand the 8 minutes and the law school hypothetical, but it's your home. It's castle doctrine. You have no duty to retreat.
There's 2 children in the house. Yeah. It's a home invasion. There's 2 children. My goodness gracious. Wow. Yeah, this is not going to make people want to move to Massachusetts, by the way. Okay. Think Tank, staying with us. We've got more of this interview, so let's continue to listen to it. Does he say anything in this second part of this interview that perhaps makes the case for manslaughter?
Come.
You know that a gentleman named Jonathan Latender broke into a home in Chesterfield, and you know that the defendant, Brian Camp, shot him to death. That first shot is self-defense. We're here today because of what happened in the next 8 minutes and 37 seconds. Brian Camp uses that same weapon with the same hollow tip bullets. He walks over to where Jonathan's lying. He shoots him in the head. And Mr. Camp, after all of this, believed that he needed to shoot again, because he needed to stop this thing, because it clearly was not stopping.
I'll tell you what, if I was in that prosecutor's office, this would be one of those cases that I would try to avoid, right? I mean, this is not an easy case to win. You're going after a guy who's the victim of a home invasion for what he did to the home invader, who was threatening to kill him and was physically assaulting him, gouging his eyes. This is unusual. Take a listen to more of the police interview of Brian Camp, the man who's now been accused of manslaughter.
How many times do you shoot?
Once, twice, I don't know. Maybe twice.
Okay.
I don't know.
What happened then?
He hit the ground.
Okay. Then what did you do?
I went outside to find out where she was, because she got out of that house and I guess was calling you guys or somebody.
And then you went back into the house.
Yeah, I got dressed.
Okay. Was there any more shots fired when you went back into the house?
No.
Okay. Did you check on the individual?
No, I left him there.
Okay. So when you went back in the house, you bring your gun in with you?
I don't think so, no.
Okay.
Yeah, no, because I just went upstairs and put my clothes on for him.
Yeah, that's what I don't know. Just getting information. I'm trying to clarify it. That's what they're saying. That maybe there's another shot on the 911 call, maybe. No,
I don't remember.
That's the case, right? That's the case that they're trying to make. Bring back in our think tank, Eklund, Mercy, Kirk, Nurmi, Nima, Romani. Kirk, this is where they're making the case, right? You look at him there. He looks a little frazzled at that moment, asking about this second shot. Now, I don't know how far you want to read into this, but that's the prosecution's case. It's all about the second shot. First shot, fine. 8 minutes later, second shot, no good. And it seems in the interview there is some gray area, or perhaps he's purposely not remembering the second shot. What are your thoughts?
But this goes to Eklund's point about talking to the police, and while I do think there's aspects that help him, keep in mind, he is in a state of hypervigilance, if you will, still, I think, at the police station, because as Eklund pointed out, he's still got the blood on him. This event happened in very recently, right in the middle of the night, and he's up at 6 in the morning talking to the police. So some of that can be, I think, accounted for by the fact that he was still amidst this event. It was a stressful event. This person is still in his house, potentially moving. I think there'll be some forensics of whether or not that's the case. But in some ways, while Eklund's advice is well taken, I think Nima makes an excellent point as well, that this might actually help him, because he doesn't remain silent. He doesn't try to dodge the police. He doesn't do anything wrong. As you said, he calls 911. He speaks to the police. I think this is going to translate to the jury, even though the jury says, hey, they're not supposed to draw any inferences off someone's right to remain silent. I think juries have more respect for someone who will stand there and talk to the police, especially in a situation like this. And that could be enough, because this jury, I don't think is going to need very much to hang their hat on, given the circumstances around this case.
And Kirk making a great point, Nima, about the stress involved. Like, he's just been involved in being attacked and taking the life of someone else. You know, when police officers are involved in justifiable shootings, they're not subjected to an interview quite like this. It's a little bit different, right? Usually they get the union rep is with them. They get counsel. It's a much more controlled environment. It's different for him. He's just, I mean, he's a young guy. He's a father, but he's a young guy. What are your thoughts about the second part of the interview, the most important part for prosecutors, the second shot?
I'm not concerned about the second shot as much as the prosecution thinks it's dispositive. And here's the problem. They've already conceded that the first shot is self-defense, which the prosecution never does, right? So now you've taken the first part of the case away, and you're making this really kind of convoluted argument that it's not murder, right, because it wasn't self-defense, but somehow his belief was unreasonable. It's some sort of imperfect self-defense argument. And that's very difficult for the jurors to parse through. And we know the conventional wisdom in these types of cases is that the defendant has to take the stand, but maybe he doesn't if the prosecution introduces this video. So, you know, there's a lot of off-ramps to victory for Brian Camp in this case.
Absolutely. Do we have time to listen to one more piece of his interview? All right, let's take a listen to another piece of his interview. Eklund, let's watch this.
Have you ever tried to confront anybody that she was, you know,
Nope.
cheating or whatever we want to call it?
Nope.
Okay.
Because to me, like, to do this over somebody cheating on you.
To do what?
To shoot somebody.
Yeah.
Over somebody cheating on you, you can just walk. Like, I own my own house. Yeah, I can go to my own house.
Right.
So, yeah, no. That wouldn't, no. Because, I mean, what would, I don't know, is that what you guys think? What, do you think they were?
No,
I said? Like, it was, was I the person that they didn't want at the house?
No.
Like, I don't.
No, I don't think so.
He just looks like he's being totally honest through all this.
Yeah. I don't even think it should go to the jury. I think it should, a motion for directed verdict should be granted. I think that there should be a motion for malicious prosecution, because there's no reason. There's no reason at all. He doesn't have any criminal history that can, that they are hanging their hats on. It's just it's the second gunshot. The second gunshot in his home with his children, with the mother of his children. I don't understand why it's still going on. I think that the prosecution should stop the bleeding and stop this foolishness. Unless you can show me that they've done this, this type of prosecution before, then I don't know why this case is still going on. We see somebody who obviously is using the self-defense that he's been granted to protect his children. And once that first gunshot, that was to destabilize him. Obviously, he's still a threat, and he gave another gunshot. I don't see why we're still here. And the fact that they conceded, I'm making a motion for malicious prosecution. I think that he should be able to sue the prosecution, like it's bad. This is bad. This should not have gone past.
You know what, Eklund, you said those words, directed verdict. I think it's a possibility here. I don't know the judge, but this is an actual possibility where the judge will take the reins on this and not even let it get to the jury. Great job tonight. Great to see everyone. Eklund Mercy, Kirk Nurmi, Nima Romani. Appreciate it. We'll see you again really, really soon. When we come back, I will reveal something else you need to know tonight, plus coming up next hour. Tonight on Vinnie Politan Investigates, the Idaho student murders 4 innocent victims. One suspect with no criminal history. Who did he target in this brutal attack? We investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
I'm Vinnie Politan. Welcome to Closing Arguments.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinnie Politan, weeknights at 8, 7 Central, only on Court TV.
Welcome back. Time to reveal something else you need to know tonight. Let's take a look at the big board. What do we have? Leilani Simon sentenced to life with the possibility of parole. The young mother, what did she do? Murdered her child. This little guy, little Quentin, murdered him, then threw him in the trash. They had to recover his remains at the landfill. Let's take a listen to the judge and then Leilani's mother.
Little Quentin Simon's life and death impacted many, many individuals, but also the community at large. Leilani Marie Simon, the court sentences you as follows. Count 1, malice murder, felony, life with the possibility of parole.
I know drugs has taken and had a huge impact on our entire lives. Even as Leilani's childhood, I failed her as a mom. I allowed addiction to take over my life at a young age. And you and your brother were just babies. And you lived with my sister. And I made sure you were okay. And through those times, it was still really hard on you because you wanted your mom. Just like I know they're gonna want their mom.
There's Quentin. I understand drugs, addiction, huge problem in our society, but then when the state intervenes and tries to help this child and you fight to keep him, you fight to keep him so you can murder him? Unforgivable. I wouldn't have given the chance for parole, but this judge did. We'll see how that turns out.